Welcome, everyone who is joining us live today and those watching this recording afterwards. My name is Dr. Laura McGuire, and I am with the National Center for Equity and Agency. And today's webinar, we have the incredible honor of discussing how domestic violence and mediation correlate and how to make them more trauma-informed and survivor-supportive with the Honorable Retired Judge Julie Field, who I would also call a mediation change agent, someone really innovating and evolving this field. I'm so excited to have this conversation with her today. Thank you so much for being with us.
Well, may I call you Laura?
Yes.
All right. Well, Laura, thank you so much for inviting me. I am passionate about ensuring that survivors of domestic violence and other trauma have the opportunity to have the full gamut of what is available to them in the justice system. And mediation is one of those things that people often shy away from. When it can be enormously empowering with the right mediator, with the right attorneys, with the right approach, and with the right understanding of what the process can do and what it can't do. So thank you for including me.
Awesome. So I'm going to start with just some very basic questions. And number one is, tell us a little bit more about who you are. I mean, like I said, even just your titles, people can tell this is someone who's done a lot of amazing things in their life. But what is your background and how did you find this to be your niche? How did you grow and develop that? What called you to that?
Yeah. Well, I started really doing domestic violence work as a law student. In Chicago, I worked for a small law firm, two women, and one of them was doing domestic violence work. And this was in the 1980s, long time ago, when, they didn't even have a name for it. They didn't even call it domestic violence. It was just the beginning of people thinking about this as a systemic problem. And so I started with that work and then became a law professor a few years later at the University of Michigan, where I was able to focus with my law students on domestic violence and family law and other issues involving women in the justice system, such as equal protection and employment discrimination and that kind of thing. So I really have focused on domestic violence throughout my career since being a law student and then as a law professor. One of the things that I did as a law professor, I went from University of Michigan to Washburn Law School, where I learned about mediation. That was the first I had learned about mediation because it wasn't something that was taught when I was in law school at the University of Chicago in the early 80s. But I learned about mediation and started thinking about how can this process really be used to empower people who have been disempowered in their relationship. So I started thinking about it, writing about it. When I left Washburn, I went to the University of Denver, where I ran a domestic violence clinic, and also started a national organization to teach non-lawyers about the law, particularly around domestic violence, particularly advocates and folks that work with survivors of domestic violence, called the Confidentiality Institute. And I taught lawyers how to try family law cases involving domestic violence. So I started an institute. I was also doing mediation and was learning and watching and figuring out ways that mediation can help survivors and is a process that can be empowering rather than disempowering, as many people often think. When I had the privilege of becoming a judge, I could see how my mediation skills helped me in that capacity. Since retiring from the bench in 2021, I've done two things. I've restarted a mediation practice where I do mediation and arbitration. And I also started the Consilium Institute with my co-founder Heidi Webb, and we are transforming the way divorces are handled in every court in the country. So that is that is my small post-retirement goal, and we're well on our way to training lawyers and financial advisors and therapists and anyone who works in the family law space to do things better. So this is part of that. This has been sort of an ongoing mission. I feel like social change, social justice is something that I've had a calling for, and this is where I've found a place that I can make that work.
Well, thank you for doing that because, as you said, you've been doing this for decades. Many of our audience members,
Violence, yeah.
yeah, including myself, you've been doing it as long as we've been alive, right? So it goes to show there has been so much evolution and change, and yet there is still so much to be done.
Mhm.
And one of the things I also want to ask you up front, because again, a lot of people watching this are in situations where they're either planning to leave, they have left, it could be years later, they're still embroiled in abusive dynamics. And so many times, myself as a survivor, the survivors I've helped as an advocate, we're told, okay, we're going to do this. Our attorneys say, we're going to go to mediation.
Mhm.
Okay, well, what is that?
Mhm.
How do I prepare for it? What do I bring? So, just starting with those questions, what is mediation? And what should a survivor be thinking about, preparing for, or advocating to their attorney for when they have a mediation scheduled?
Right. So mediation is one of a panoply of what's called alternative dispute resolution. You might hear an attorney talk about ADR. It is one choice. There are other choices such as arbitration is another one, or early neutral evaluation. You might hear that term, or some others in your region that are popular. But mediation is probably the most common one. And what mediation is it involves a neutral third party, hopefully someone who's trained in mediation, although not every state requires mediation training. Someone can just announce that they are a mediator and that they want to help people resolve things without any particular training. Many jurisdictions, though, do require training and some kind of certification. But the idea is that a neutral third party will assist the parties who have a dispute. It could be a dispute about child custody. It could be a dispute about, your neighbor's dog. It can be big issues or small issues. That where that neutral third party helps the participants reach a solution that they create, rather than having someone else, like a judge, decide for them. So the mediator brings folks together and has a process that they go through to ensure that the idea is it's a voluntary process, although it is court ordered in many jurisdictions. So how can it be voluntary if it's court ordered? But people come to mediation with the idea of resolving the issues. Now, one of the challenges with that, with folks who have been traumatized by the other party in the mediation, is that it doesn't feel like that is a voluntary process. It doesn't feel like that is an open process. And it can feel like that is something that can be disempowering rather than empowering. But because so many folks are going through mediation or ordered to mediation, including folks who have experienced trauma with the other party, you need to keep in mind that it is a process that you as a participant have control over. You have control over the outcome. You have control over what and how the process ends. The mediator has control over the structure of the process and can set up the process so that people can meet in separate rooms and have an opportunity to talk with the mediator privately. The mediator controls the process to ensure and should ensure that there is safety. But the participants have the right and the ability at any time to terminate the process and say, this is not working for me. This is not something that is helpful to me. But it can be that opportunity and an empowering opportunity to be heard, to tell your truth, to be able to focus on things that a court might not focus on. For example, I had a mediation recently where an abusive party basically told me in caucus, which is the private session, that he was doing this, he was continuing the litigation well after the divorce because he wanted to keep engaged with his ex. So he was completely honest about that. And I, as a mediator, it was my duty, I think, to ensure safety and to call him out on that, which I did with his lawyer. And I told the other party, mediation, is the hallmarks of mediation are it's a neutral third party, it's a confidential process. The mediator controls the process. The parties control the substance and the outcome, and it ultimately is voluntary. But unless you have someone in the mediation role who really understands domestic violence, then it can easily be manipulated.
Yes. So thank you for kind of circling back to that point, because just a few months ago, I was in a training that a school was putting on, and that's one of the things they said, we want to make sure that people understand this is incompatible. Domestic violence and mediation cannot go together. And the reality is that so many times survivors, whether it's domestic violence or sexual harassment, Title IX issues, all different kinds of things, are not receiving the justice they deserve in the court. And so this gives them another path towards therapeutic jurisprudence.
Correct.
And on the other hand, I think also the media has a major issue with this, in that when particularly sexual abuse survivors come forward and it's a case where there's maybe a celebrity involved or a political figure, and they say, oh, they settled out of court. AKA, they made it up, or it couldn't have been that bad because that designation is somehow seen as lesser.
Right.
So can you address a little bit of this concept of it being a lesser form of justice and that historical foundation of seeing this as incompatible, even though it can often be maybe the only avenue that's really available to a survivor to be heard, as you've said?
Right. So first of all, I would say, although it may be seen as a lesser form of justice, in many ways, it is a more powerful form of justice for an individual, because you have control over the outcome. With a court, if you're presenting your case to the court or to a jury, you don't have control over the outcome. You're putting your life and your issues in someone else's hands for decision. With mediation, you have control over the outcome. And if there's one thing that I would like your audience to remember, is that they have control over the outcome in a mediation. A lawyer might pressure them for resolution, or the other side might pressure them for resolution, but they ultimately are the ones who have control over whether they reach an agreement or not. Now, there might be consequences for not, like going to court, and what the ramifications of that could be depending on your court officer. But you do have a lot more power and voice in, and can have, in a mediation process. If you are a survivor who is looking to mediation as an opportunity, which is what I would encourage you to do, make sure that the mediator that you are engaging is someone who understands, truly understands, domestic violence and coercive control, because it can be another place where someone who is abusive can use their charm and their, they're coming off as someone who is together and polished, because many times, as you know, people who use violence in their interpersonal relationships can be very polished in front of other people, right? And can be very persuasive. So you need to remember that you ultimately have the ability to say no to any offer that's made, to make counter offers, and to walk out and to terminate the process. The mediator is, as I said, in control of the process, but besides finding a mediator who is very well versed in domestic violence, and that is a fair question, I think, to ask any mediator. What is your background, and have you dealt with cases involving domestic violence, and what is your approach to it, to make sure that they are conducting the mediation in a safe and appropriate way, both in terms of how they generally approach cases, but also how they will specifically approach your case. And a couple of examples, sometimes mediators will say, well, I'm impartial, so I have to treat these parties the same. Being impartial or being neutral is not the same thing as being impartial. Being impartial, you're impartial to the topics, right? You're impartial to the particular situation or circumstances. You can be impartial, but you can't be neutral about safety. You need to, as a mediator, you need to make sure that people can come to the table fully equipped to address the issues. Just as I would not require someone to walk up the stairs to my office if they're in a wheelchair, I am not going to require somebody who is not able to use their voice in mediation to expect them to be sitting in the same room 5 feet apart from the other person, if that is an uncomfortable, intimidating situation that will not allow them to fully participate. So my job as a mediator is to ensure that people fully participate, and ensuring that there is safety in the process, both physical safety and emotional safety, is critical to that. If you have a mediator who says, oh, I don't want to know anything about domestic violence, or I don't want to know anything about your history, that's not a mediator that is appropriate for a case involving domestic violence. And I can give some examples too of some programs where that really conscious focus on domestic violence is extraordinarily important and helpful.
Yes. And I think everything you're saying about that awareness, and not only education, right? Because people can be aware of things and have heard it and say, I'm not really internalizing this. This is not something
Sure.
I am practicing when I show up in these environments. And yet, those who do want to differentiate themselves that way are so crucial. One of the things that has made me so proud of my company's trainings on trauma-informed care for legal professionals is how many mediators have taken it, and that eventual goal of being able to have every crisis center in every state be able to direct people towards individuals like yourself, because oftentimes they don't even have a recommendation. It's, I hope your attorney knows someone and I hope you find an attorney, but we don't have people we can say have these competencies or these perspectives, these lenses through which they'll be guiding you.
Right.
So I'm curious, when someone is selecting a mediator, what are some things that they can do? You've kind of touched on this a little bit, but kind of a checklist, maybe 3 or 5 things that they can be asking specifically to select someone that they know will be giving them that positive experience.
Yeah. I would ask them how they will ensure safety, how they will ensure voice, that people can be heard, and how, I mean, beside, we already talked about the experience, right? So asking foundationally what their experience is, but how they will address issues that let me put this differently. How will they feel as a mediator if there's not a resolution? In other words, what are their goals in mediation? Because it is, people think that the goal of mediation is to reach a full settlement of all issues, right? Or even some issues. That's not necessarily the ultimate goal of the parties in mediation. It could be that the goal of a survivor in mediation may be being able to walk into the room and look the person in the eye and speak their truth. And that could be a successful mediation. So how does the mediator measure success? And very often you will hear lawyers and mediators say, well, it wasn't a full agreement, so, it wasn't a good mediation. That's not the measure of mediation. The measure of mediation is, were the parties heard? Was there an opportunity for them to speak their truth? And, of course, you are going through this process and you're paying this money so that you can reach a solution, but it may not be in that moment that you reach that solution. It may be later down the road, but you have spoken your truth and you have set things out in an appropriate and powerful way. The mediator, one question for the mediator is, do you do screening for domestic violence? Do you ask, is there domestic violence in this case? Beyond just saying, is there a restraining order or not a restraining order? Because as you know, as everyone here knows, that is not the only standard for determining if there is domestic violence or coercive control in a relationship. So make sure that the mediator is doing an initial screening. There may be a benefit in some cases involving domestic violence to having co-mediators. So having a mediator who is a mental health professional working in partnership with a mediator who is an attorney can be extraordinarily helpful, because then you get multiple perspectives. You can ask them what their protocols are about safety. Zoom is a very common option now for mediation, which also means that your people who are involved in mediation have in some sense opened up a national opportunity for mediators who are expert in domestic violence rather than just using someone local. So what are the safety protocols? Is it going to be a mediation that occurs at the courthouse because there is security there, right? Is it a mediation that is going to occur by Zoom? What is the expectation of the mediator as far as having people together in the same space, even if that's the same Zoom room? And knowing what that is so that you can prepare for that. And remember that it is always your choice whether you participate in mediation or not. And you should not be punished or have it held against you if you opt out of mediation. Most states allow for an opt-out of mediation if there's domestic violence. You should not be punished, chastised, shamed for doing so if this is not a setting that will work for you.
Yes, thank you for all of that, and especially that note on co-mediation and how you can have these different voices and perspectives to collaboratively give you that best experience possible. I've been very fortunate to be called in as a mediation advisor and bring in restorative practices in situations of interpersonal violence. And the more people you have there that can come with those fresh ideas of, here's how I think you can be heard differently, or I'm hearing you say this is really important to you. And yet, maybe you're not feeling like those wishes are being honored. So let's figure out creative solutions to that. That is so key and really is a cornerstone on whether someone feels like this was part of their healing journey or whether this was just re-traumatizing.
Right. Let me,
I
just
see that we
add,
have people raising
let
their
me
hand. Oh,
I
yes.
just want to add one more thing
Yeah.
to the safety protocols. It's not just the where and when, but also talking with your mediator privately ahead of time. And the mediator should talk first with the person who is the survivor of domestic violence, and do sort of an individual, what do I need to know to prepare? Talk with them first, but also talk with the other party and say, what do I need to prepare and what will I hear? So that can be helpful background, but create a safety plan within the mediation as well. And say to the mediator, if I really need time to step out, I'm going to scratch my forehead, or I'm going to pull my ear, or I'm going to rub my chin. If I want a separate conversation and I'm afraid to say that, then I'm going to do this, or whatever the signal is, to make sure that you've got some understanding with the mediator of when you need a break and when you want to have an individual conversation with the mediator.
Yes. Thank you for saying all of that. And yeah, there's so many layers of things that can be done to, like you're saying, make that person feel like I have an out, I have a voice, and to regulate their nervous system too, which I think often gets overlooked. People say, it's just any room, any location, anywhere, any time of day. You can both come in at the same time or have to use the bathroom at the same time. And no, the way the body is going to react to that is going to completely alter the trajectory of how that conversation goes. So being mindful of those things is really important. I'm seeing we have some people raising hands. If you can put questions into the chat, we'll try to get those in for the last few minutes. Otherwise, feel free. We'll have Julie's information at the end. You can reach out to her or myself. The last question I wanted to touch on during our last few minutes here, though, is as that kind of 10,000-foot view. This is a huge topic. This is complex. We're just touching on a little tiny bit of it today. What are some things that you want every attorney who represents victims and every advocate who is working in the space to know about how they can better support this process for their clients?
First thing, really, truly, honestly, dig down and understand coercive control and how that can manifest itself. Bring in people to help you understand that. That could be also an advocate at mediation, right? That's another safety protocol. Make sure that you are asking, as an attorney, for example, or as a mediator, asking the client or the parties, the party who's the survivor, what do you need to stay safe? How will I know if something is going awry? What are some trigger words or phrases or topics that might be concerning, right? I mean, one of the mediation can be incredibly empowering, but it can also be incredibly disempowering. And the reason that it can feel so disempowering is because the abusive party often comes in with an agenda. And that agenda is to maintain power and control, and to control the process, and to show what a great guy they are, right? And to get the outcome that they want, and to bully and pressure and use that forum, which is less controlled in some ways, or can feel less controlled than a courtroom. It is up to the mediator to stop that behavior. It is up to the mediator to, first of all, and it's up to the survivor to advise the mediator of what they need to look for to make sure that they are able to identify and address what the issues are and what the concerns are.
Thank you for that. And it is my ardent hope that many people hear these messages and take them to heart and know that these options are open to them and find people who are passionate about making these experiences so positive and productive and healing for the victims involved. Thank you so much for this time. How can people get in touch with you if they want to learn more? Or you also are a private judge still, and maybe touch on
Yes.
that with the information of how to contact you.
Yeah. Yeah, in some states there are opportunities for private judging, so you can hire a judge to decide your case. You can ask for a special master, which is someone who's usually a retired judge who can help control the process of leading up to hearing and decide certain motions. Arbitration with a trained DV arbitrator, someone who decides, but on a private basis, it's not public, it's not in court, it's not with a judge, is another option. So there's a whole range of what are called alternative dispute resolution processes, and mediation is just one of them, but as I said, it's the most common one. And I'm putting my 2 emails in the chat, and one is for the Consilium Institute. And one is for my mediation practice. I have websites for both consiliuminstitute.com and jfieldmediation.com. So there's more information there.
Thank you so much. And thank you to everyone who's joined us live today. If you're watching the recording, all of this information will be in the description as well. We appreciate all of your energy in advocating for a more trauma-informed and victim-centered world. Thank you so much.
Thank you. Thanks for what you do, Laura.